Hi, Anchal.
Hi, Vishwadit sir. Hi, how are you doing?
I am very good. How are you?
I'm good too. Good to see you. I think we can begin with our session now. Hi, and welcome you all to this session on insolvency. Happy to announce that EBC Learning is running insolvency as one of their featured courses on the platform. And this is our third live session for this course. We will be discussing real estate insolvency, which will include topics like reverse CIRP. And we have with us today Mr. Biswajit Dubey, who has over 19 years of rich experience in the legal field. He's a partner at Serial Amarchand Mangaldas in
Not
dispute.
anymore. Not anymore. I think you have my old
Okay.
profile.
Okay, then I'll just hand it over to you now to get yourself introduced to all of us. Over to you, Biswajit, sir.
Thank you. Thank you so much. Thank you for your kind introduction and thank you for having me. Uh, I, uh, I was a partner at Cyril Ramachandran until July last year, and since then I have started my own counsel practice. Insofar as insolvency, more particularly about real estate insolvency is concerned, that's something that I had the occasion to do quite a few matters. I am continuing to do quite a few matters. In the beginning, I did the JP matter. Then I was involved in Amrapali. Then I was involved in Supertech. So I had a good experience, and I am still getting to see what is happening in the matters personally or in my interactions with other professionals. Uh, so it is something that I would like to talk about. It has its own unique set of issues. Before I start, I would first of all, of course, welcome you all, and you'll have to bear with me for the next 1 hour or so. The Just so that we are on the same page, I would want to start with talking very briefly about insolvency, so that we understand why insolvency per se, insofar as IBC is concerned, uh, in the context of real estate, brings out its own unique set of problems. So without real estate, let me just speak about what IBC is about. Essentially, and I'll not give the background of what law was there. This is just purely about IBC. Under the code, the purpose is that any corporate entity which, uh, more particularly actually a company, if it is not able to pay off its debts as a matter of fact, then such a company, there is an option available to the creditor, and even the company itself may approach NCLT and satisfy that if the minimum threshold, which was earlier 1 lakh, now 1 crore, is met, then insolvency should be proceeding should be admitted, and a process called corporate insolvency resolution process should be initiated, and the process should be run. Now, so first stage, let's assume that there is a debt, either financial debt. I'm not getting to too much nitty-gritties right now. Let's just say that financial debt can be compared to any loan, and operational debt can be compared to any money towards supply of goods and services. Now, once that default is proved before NCLT, then the process is initiated. So that's step one. Then a someone called interim resolution professional, a professional is appointed. His job broadly is twofold. One is to run the process of CIRP, and I'll come to that in a bit. The other is also to continue running the company as a going concern, which is also equally important. uh, the board of directors is suspended. So one can very loosely say that the IRP is supposed to, IRP who later gets confirmed as the resolution professional, is supposed to run as the CEO, MD. One may loosely say that. So he's the boss of the company, and his duty is to run the company as a going concern. Now, then what is the process about? The process is broadly to invite claims of any creditors who may have any claims or legal proceedings against the company. Under the code, it's called corporate debtor. Now, the claims are supposed to be verified by the IRP and categorized in broadly two categories. The claims could be financial debt, operational debt, and any other debt, three broadly. So, the role of financial creditors who hold financial debt is in the process way more important. What they do is that once their debt is verified and their claims are admitted by the IRP, they constitute of something called Committee of Creditors, in short COC. And COC has a very crucial role to play in the process. And one of the first things is to either confirm or reject the interim resolution professional as a resolution professional, or reject him and appoint someone else. Then after this is done, then the RP takes over. Now, then the RP, as I mentioned, that invite claims, and then he also is to supposed to uh, 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 take custody or of all the assets of the company and prepare a list of assets and liability of the company. And then he's supposed to invite, again, there are nitty-gritties into it, but broadly speaking, he's supposed to invite people who may be interested in taking over the company. So basically invites resolution plans. So there may be some eligibility conditions which may be laid down. But anyways, not getting into that, then people submit their interest and ultimately submit their interest and finally plans to take over the company. Of course, there are some checks also that certain category of persons and entities are prohibited from bidding, specifically under 29 capital A, but not relevant presently. Now, their plans, insofar as legal aspects are concerned, are examined by the RP. And insofar as commercial aspects are concerned, are examined by the COC. And once COC approves, it votes on the plan, and then one of the plans, whichever receives the highest number of votes, gets approved by the COC. And then finally, if NCLT is satisfied and approves the plan, then that plan is the successful resolution plan, and the party which had person or entity or party, whoever had submitted that plan, becomes a successful resolution applicant, and in terms of the plan takes over the company. So the basic point that we see in the process is that the purpose of code is successful resolution of the entity. And if in a given case this does not happen, then the company goes into liquidation. Now, essential part of the process is to resolve the company. Broadly speaking, what I have seen from my experience in that in a lot of cases, the debt which, again, not going into the reasons, but the debt which has been taken by the company becomes unsustainable. The interest rates are too high, the company is not making enough profits or revenues to be able to pay off that debt. Now, in the process, therefore, the debt is reduced insofar as the entity is concerned, because if, let's theoretically take an example that the overall debt was 100 rupees in the earlier situation, a resolution applicant may come and say that I can only pay 50, and then 50 is to be accepted. If COC accepts the plan, then that 50 is the debt that he has to repay. That rest 50, insofar as the new under the new management or in its role, new avatar doesn't have to pay the balance 50. So that perhaps is the market value of the company, and basis which the company is taken over and the company continues. Broadly speaking, the idea is resolution. The company continues as it is in a more hillier status. Now, coming in this background, I would now bring in the real estate aspect. In real estate situation, what happens typically is that it is not like there is already some, let's say, a land or a factory which is available. You have workers, everyone is in place. You just broadly need to have enough money after paying off the debt, of course, reduced one, to continue running the operations, and then you generally start making profits. Insofar as real estate entities are concerned, what we have seen is that there is a land for which full payment perhaps would not have been made. Then some money would have been taken from the banks. Then money would have been borrowed from the allottees or home buyers. All this money is taken by the developer or the whoever is the promoter of the real estate project. Now, when they have to once the company goes into insolvency, typically what happens is that they are not able to deliver the project and not able to pay off their lenders. Then when it is admitted into insolvency, because relatively proving default is easy, because if you're not delivered the project in time, then it is a default, and then the project or the company is admitted into insolvency. Whether a resolution applicant be interested, or for a resolution applicant the project is viable or not, is a big question. Because how will a new entity make money in the process? They make money if they have enough unsold units from which they will generate revenue. But if most of the units are sold and the bulk of the payments have been received by the earlier management, then there may not be enough margin for the new resolution applicant to generate revenues, and for them to realize the money that they would have to invest. So therefore, there are some unique problems insofar as real estate projects are concerned, because very frequently we see that a lot of money has already been taken. Almost 80%, 90% money is already paid by the home buyers, and then their money is stuck. And even for a new RA, investing and recovering looks very difficult. Now, again, coming back to another aspect of it, that in a typical insolvency situation, the committee of creditors constitutes of the lenders. Now, that's very, very different insofar as real estate cases are concerned. To give a background, this was not always the case. Earlier, this was like any other insolvency, and the committee of creditors was constituted of lenders. Now, there was a lot of hue and cry about it, because the home buyers felt that they effectively had no rights. It is, of course, arguable whether they would be considered as a, before the amendment was made in the insolvency in the bank IBC, whether they should be treated as a financial creditor, operational creditor, or other creditors. I'm not entering that debate right now, but essentially they were definitely not part of the CUC. They were not financial creditors. So that bit was clear. So they could not initiate, and then once it was initiated by someone else, their right to pursue proceedings before consumer forums, etc., was curtailed. So the home buyers felt that IBC actually was taking a lot of their rights away and not giving anything in return. And we saw this in the case of JP Infratech Limited. There we had 24,000 home buyers. Now, this is a huge number. So a lot of real estate related amendments were brought in. One of them was that, by way of a definition, real estate allottees were defined and added in the definition of financial debt or financial creditors. So real estate allottees could also initiate. Now that again brought another problem. The problem was that any home buyer who was unhappy with his dealings with the builder, which is very, very common. I have rarely seen any home buyer who's happy or satisfied with his builder. So any aggrieved home buyer, if there was any dispute, could initiate proceedings. And mind you, initially the default threshold was 1 lakh. So it was very easy for anyone to show default and initiate insolvency. Now, insolvency has very major repercussions. It impacts everyone, all the home buyers also. And builders may have, same company may be developing 10 different projects. Even in a project, there may be 10 different towers. So the problem may just be with respect to one tower out of, let's say, 10 projects, and and that too in one tower of one of the in one project, one tower in one of the projects. So whether it was right on the part of one home buyer to be able to bring the whole companies to the knees was thought to be a little unreasonable, and therefore IBC was amended again in 2020 and a minimum threshold was brought in. I think that one can always debate the whether the threshold is right or wrong, but I personally feel that this was a good thing to do, that the threshold said that either 10% of the total number of home buyers or 100 number of allottees was the minimum requirement who could initiate the process. Just 1 minute. So that this, according to me, with experience, I can say that was a welcome thing to do. Of course, at times, a lot of home buyers complain that it is quite onerous for them to get in touch with and convince other home buyers. But I feel that if there is a genuine default on the part of the builder, uh, uh, most likely 10% people would get together and or 100 number of people would get together and be happy to or be a part of the process to initiate insolvency. So that threshold was necessary. One can always debate about whether what should be the right number in a given case. So this is one another amendment that was brought in. Now going back, having home buyers in the COC brought in another problem, because how do you typically in a given situation the number of lenders could be 2, could be 50, maybe even 100. But in case of home buyers, there could be the minimum number usually starts from 100. So whether how do you have those COC meetings? You can't have a meaningful discussion. And I have seen home buyers attending NCLT hearings also, and typically it's a crowd. They are not lawyers, or most of them are not even experts on commercials. It's like someone like you and me who's just concerned and genuinely concerned about his or her life savings being invested in a project and him not getting anything in return. He's waiting for a number of years, so his concern is that give me my unit, fully constructed unit, and he's naturally not bothered about whether the company survives or doesn't survive. To that extent, I think a home buyer can be equated. I'm not talking legally, but with a operational creditor, because operational creditor typically would be more interested in recovering his money than the resolution of the corporate debtor. But be that as it may, so having home buyers in a meeting, putting them together and having a meaningful discussion was very, very difficult. In fact, we saw that home buyers didn't even attend the meetings. Who would actually imagine all home buyers will be working somewhere, right? A lot of them are not even in a particular city. So they whether they would travel before COVID, whether they would travel and attend hearings, all this was impossible. So another amendment was brought in under which uh, a particular class of creditors in the COC could have their own authorized representative, AR, and AR will be another resolution professional. So by way of voting, and any person who receives the maximum number of vote would be appointed as the authorized representative of the home buyers. It can be for an other creditors also, but we haven't seen such cases. At least I have not seen. For home buyers, it works out relatively well, because what the authorized representative, in short, I will call it AR, what AR does is that, let's say, in a typical COC meeting, the agenda, notice, etc., is circulated, and people are invited for discussion. COC members are invited for discussion and eventually voting if required. Now, in this case, the AR can't really take a decision on his own. So AR would circulate the voting agendas in advance, and the home buyers are supposed to look at it and vote for it in time, so that the AR has the answers as to what is the stand that he should be taking insofar as those issues are concerned. So AR would actually collate the votes of the home buyers and then vote accordingly in the COC. Now, this is how I think this was a good way to manage it, because I personally feel that bringing in home buyers to assuage their concern in the COC is a debatable issue. I personally don't agree that they should have brought in. Maybe there could have been some other solution, but bringing them the COC was not the best thing to do. But be that as it may, it is there. Now, the AR votes for the home buyers, and this is how the process continues. Now, again, as I said, that insolvency, insofar as real estate, has its own unique set of different, very, very unique problem. What we see is that very rarely we have seen successful cases. For example, JP Infratech Limited, which first admission order was passed in 9th August 2017, it is still not resolved, right? Ultimately, it's actually been 7, 8 years and it's still not resolved. Now, you can't even blame anyone because it has gone multiple rounds from NCLT to LAT to Supreme Court. And perhaps, hopefully, this is the last round that the matter would go to Supreme Court. At NCLT level, almost everything is resolved now. Now, why does it not uh, get resolved? In my assessment, the reasons are multifold. First is that everything said and done, at some level, the promoters who have a vested interest and, of course, uh, responsible for the insolvency in the first place have an edge insofar as completion of the projects are concerned. They definitely have an edge over anyone else. Of course, assuming that they have the financial wherewithal. Now, one of the problems that they bring in is that they never let go. So they will continue to litigate from day zero forever because they don't want to give up, and therefore the litigation that they bring in delays everything. That's number one. Number two is the issue that I earlier mentioned, the viability and feasibility of someone else coming in and completing the project. I'm trying to mention some of the problems. It doesn't mean that they are all, this is not exhaustive. There could be many more. Third is something that I have seen that normally, with respect to any other company, the promoters or the shareholders, the company owns everything. Let's put it this way. Most likely the land, the factory, etc. Everything would be the employees would be owned by the company itself. In a real estate project, typically it is very, very common that the land is owned by X. Then there is a developer who develops the project. Let's call him Y, him or her, that entity as Y. Then the project thereafter, which is what typically the promoters do, that insofar as the subcontract part of constructing the project is concerned, that is outsourced to a third entity, which is actually mostly the promoter's own set of entities, because that's how they make money in the process. So you have a landowner, you have a developer, and then there is a third party which is actually doing the construction. Now, this brings in its own unique set of problems. Even the landowners can be different categories. Landowner can be a separate legal entity or a set of persons. It is also possible that it is not owned by one single person. For example, I have seen cases where some villagers owned a piece of land together, or some people jointly purchase some land from some different set of people. So you have 10 or 20 set of people who owned a chunk of land, and then a project is being developed there. This is one situation. The other situation is where the land is owned by entities like Noida or Greater Noida. So some of you may know that in Noida or Greater Noida, the land is owned by Noida, Greater Noida. It is then leased to the project developer, right? And they do the construction. And in lieu of that, the developer pays some lease amount to the to Noida or Greater Noida. Now, Noida, Greater Noida brought in their own set of problems. I'll come to that in a while. Now, what happens typically is that when you can't get everyone together, the landowner, the developer, because one of them may go into insolvency. Now, if the developer is going into insolvency, what are the assets that the developer has? It at the max will have the right of development of the project, right? It is not the owner of the land. And I've seen cases where the resolution applicant tries to completely oust the landowner. Now, that is on the face of it unfair that someone has given his land and he typically seeks a share of the constructed units, 50%, 40%, whatever it is. Now, what the resolution applicant tries doing is that, sorry, we will not give anything to them. Now you are taking somebody's land. So naturally, the people whose land is being taken away will continue litigating because that it is on the face of it unfair. Then if the landowning entity goes into insolvency and the developer is fine, then that brings its own unique set of problem as to but that according to me is still relatively easier. Either the resolution applicant can be the developer himself. But again, these are all if both of them are going in under insolvency, then there is another problem. Now, now coming to the Noida, Greater Noida problem. Now, again, with experience, what I have seen is that typically when the land is owned by Noida or Greater Noida, the most of the amount that is outstanding with respect to such projects is owed to Noida or Greater Noida. And naturally, so first of all, there was a long round of litigation in almost every matter where Noida said, I'll just say Noida for now. Noida said that if you don't pay my amount, my debt is a financial debt. I should first be sitting in the COC and taking decisions, which was in most cases not allowed. They claim to be financial creditors. And these litigations stalled real estate insolvencies for a number of years. Now, ultimately, Supreme Court resolved it and said that they are operational creditors. So, thankfully, one problem resolved because as an operational creditor, now you know that the resolution applicant with certain limitation, which is that they're entitled to the liquidation value of the security that they have and that they have to be paid upfront. If the plan satisfies that, then they are good. Now, but this didn't end here. Then the second round, insofar as Noida, etc., is concerned, was that they were secured creditors. So Supreme Court held that they're secured creditors. Now, as secured creditors, they have certain rights. So, and they have to be paid substantial value, which was not the original position, because as operational creditors, they are entitled to a minimal requirement. Now, so all this brought in a lot of time was consumed in litigation. And second, uh, every time a new issue was brought, the matter would travel from NCLT to LAT to the Supreme Court. And if this issue is pending in one matter, then most of the other cases would also wait for the final outcome before the higher forum. So NCLT will wait till NCLT take a decision. NCLT will wait till the Supreme Court takes a decision. And we all know, especially the practicing lawyers, that it is a long journey for decisions to come from one level to another. Now, anyway, so this brought in finality insofar as Noida issues are concerned. Then JP threw another unique problem, and I'm sharing this. In JP, what had happened was that there was this issue of additional compensation to. So again, taking a step back, Yamuna Expressway Authority acquired certain lands of farmers, and the farmers were supposed to get some, and farmers were paid their set share of compensation. Later, in some other matter, it was decided that the compensation should be enhanced. So the farmers claimed extra amount from Yamuna Expressway Authority. Yamuna Expressway Authority and JP had an arbitration dispute between them, wherein it was, at least in the arbitration, Yamuna Expressway lost and JP won. But again, Yamuna Expressway filed a claim of about, I think, 1600 crores odd rupees, saying that this liability from the farmers, once it comes on to me, who will pay? The uh, the RAs naturally would say that, look, I don't know and I don't care, you have to pay. But ultimately, thankfully, I think Suraksha has now decided that they will pay a certain amount, and that proposal has been accepted by the NCLT, I think yesterday or a couple of days before that judgment has come. So hopefully that brings an end to the JP Infratech problem, and also hopefully solve problems for others also. Now, yeah, but again, having said that, these decisions don't come easy and it takes a long, long time. So, therefore, who suffers in the process? Home buyers suffer because ultimately their hard earned money is already yeah, stuck. They have already paid most of the amount, and at the same time, they would have typically taken a home loan. They would be typically living in a rented accommodation. So, it's actually multiple jeopardy for any home buyer. I mean, I can completely relate to them, that you are paying high rate of interest, you are living in a rented, so you're paying rent, and you're not getting, you've already paid money from your pocket as well. It's not just that the loan amount that I'm talking about. In fact, there was some litigation on whether your EMI should be stopped or not. But anyways, that's not relevant for now, and I'm not getting into that. Now, everybody in the process has experienced and seen that uh, real estate cases are a unique one, and NCLT and LAT have tried finding a solution to it. So first, the problem has been identified that at times a developer may be running 10 different projects, and the problem may not be in so far as default or delay in construction, may not actually be with the whole company. It may just be about one given project. So, uh, under insolvency number, typically the proceedings are against the whole company, and the IRP is appointed for the whole company once it is initiated, and the plan, etc., is supposed to be submitted for the whole company. But once you look at this unique feature that the default is with respect to only one project, why should the other projects which are running fine should also be brought in through the process, and they have to run the process? Because no matter what we say, that IRP or RP are supposed to run the company as a going concern, a successful promoter largely is best placed to run the projects, because I had mentioned earlier that most of the developers, what they do is that they outsource the construction part and even some part of supplies of raw materials to their own set of associate entities, and that's how they make money, and they would have typically given a lot of advance. So they are uniquely placed for to enable them to complete the project, which any new entity or the IRP may find it very, very difficult, because there is no, the IRP may not will be able to drive them. So realizing that, this concept of project wise insolvency was initiated. Now again, there is no set of rules that I can tell you that this is how it happens, but what happens broadly speaking, and this is a case for amendment in the IBC also, and certain amendments uh, have been proposed, but again, not yet approved. Now, what is done in a project-wise insolvency? Let's say there are 10 projects, and in the 9 different projects, everything is more or less running on times, no serious complaints. In one project, there are some serious complaints for whatever reason. Now, the insolvency process is restricted to that specific project so that others are not impacted by it. So broadly speaking, everything is done, the process is run, but for that carved out project and not for other ones. So, one benefit, that those which are not impacted continue to operate as it is, and as units are completed or projects are completed, handovers, registry, etc. happens, and therefore they are not impacted by. Where the impact is there, there can be two possibilities. One possibility is that the promoter himself is in a position to be able to complete it. Typically, again, talking about promoters, they fail for various reasons. One is that they simply become too greedy, and they find ways to take money out of the company. Even eventually, there is not enough resources left in the company to complete the projects. So that's a hopeless case, and more or less nothing can be done about such cases. Then the second category is where, again, the promoters become greedy, or their situation is such that they start implementing too many projects. Basically, they stretch their hands and resources too far and too thin, which uh, makes it difficult for them to implement the projects in time. So you have, let's say, resources or money enough to maybe complete five, but you actually get into 10. Naturally, you will end up delaying everything. This is again a resolvable problem at some level if you focus on five. So if there is a if the project is restricted to, or the insolvency is restricted to one or two, then perhaps a solution may be found for it. So now third is where you see the process itself, CRP process itself is a time consuming process. You'll invite claims, you will then invite ultimately it can't be that from day one itself the IRP can start inviting resolution plans. So the minimum or the earliest that they can do is say about 3-4 months down the line, and it more often than not they get typically delayed. So therefore, again, NCLT and LAT realize that maybe this problem can be resolved if uh, if a chance is given to the promoter, that he can directly maybe borrow more, or he can himself put in some money. Again, there are no set rules because this is not as per the statute, but uh, but the promoter is best placed to complete it. And if he shows the right intent to complete the project, then he should be given a chance. That's broadly what reverse insolvency is. So in that, the earnestness and the financial capability, and typically if the developer can show that he has got some financer or some financial institution which is ready to support the project, then NCLT and NLT are willing to give them that chance. Somewhere I feel, again, my initial reaction to these kind of efforts, because I felt that IBC process should not be touched and should be left as it is. It brings in delays, but ultimately, a third party is more likely to resolve it once it takes charge of the whole thing. But with experience, I've realized that maybe one has to somewhere understand the fact that promoter comes with certain advantages. So once you accept that reality, because in a real estate case, uh, real resolution is the completion of project itself. It is not a case where the company has to continue running forever. Once the project is complete, even if the company doesn't do any further business, is completely okay. So, which is why I feel that, and I think the judges are wiser than us, that they also realize that the end goal is to give the home to the home buyers, because home buyers, in spite of being a crowd, and at times they get swayed by different things, different considerations, which is why at times uh, they also end up delaying things. I would also touch about another topic in a bit of filing of claims by the home buyers, because that is one of the most difficult aspects of the whole process, uh, is that ultimately, whether they help the process or not, reality is they are the worst sufferers. It is their individual suffering as opposed to institutional suffering by the lenders, operational creditors, or others. So, which is why most of the judges and the system sympathizes with them, which is why in the first place, the amendment was brought in for them to be made as financial creditors. Reverse CIRP, etc., was brought in to only help them. Uh, and although mostly we typically see that the home buyers are very emotionally charged up against the developers. This is a very, very common thing that you will get to see, because uh, they genuinely blame the developer that he's the one who's responsible for their misery, and therefore he deserves punishment. But having said that, maybe the solution also lies with the promoter himself. Now, therefore, I touched upon reverse CIRP, which is basically under insolvency in India. The creditor is in control of the process, because, as I said, that COC is the one who's uh, taking the key decisions. But in reverse CIRP, in a way, the debtor gets back in control, and he's the one who runs the process largely, right? So it is, which is why it is actually reverse, because in India, the idea was supposed to be creditor in control. Once the debtor is in control, then it is the reverse of what it should be under the code. So promoter typically finds a solution to and complete. Of course, we have also seen that NCLT and LAT keep the IRP in charge, and they also keep supervising the process somewhere or the other, so that if there is any problem, either they can resolve it, number one, or if something is not being adhered to, they can look at it and possibly also change the things back to square one, or run the normal process if things are not running fine. So there is some bit of supervision, which mostly helps. Now, coming back to the other problem, is that, and this is again a unique real estate problem. Typically, when you see now, it's been a few years of IBC, and the IRP is supposed to invite claims, and there is a newspaper publication. We have seen that home buyers uh, mostly don't file claims in time, and this brings in unique set of problems. Now, if you look at a given situation, any resolution plan will only make provision for something that has been claimed and admitted by the IRP, because it's all a time sensitive thing, that the claims are invited and are to be submitted within 30 days, and some delays condoned. But once the information memorandum is prepared, which has the details of the claims that are made, and on the basis of that, a resolution applicant has submitted his uh, payment proposal or delivery proposal, and it is approved by the COC and then by NCLT, what is the cutoff stage at which the what is the cutoff stage at which one should draw a line that, look, now nothing doing, we will not entertain any further claims. Being home buyers, they deserve sympathy and deserve a long rope, but ultimately not at the cost of the whole revival of the company or the project itself failing. So ultimately, initially from being very lenient, the NCLT, LAT, and Supreme Court have generally now become tough insofar as these issues are concerned. There are some judgments of NCLT and LAT ultimately which essentially say, because there is some important aspect of this, which is that the IRP or the RP is also supposed to look at the records of the company. If the records show that there are, even if claims have not been filed, but their record should typically show who all have booked the units, right? So they need to look at that also and give the disclosure of that. Now, ultimately, the present situation is that the resolution plan should have some provision for belated claims, right? So they typically, what I have seen mostly is that they, because everyone understands that at some stage someone will come. So what they do is that where claims have not been filed, they make a provision that if a claim is filed, say from X date to Y, for example, from the date of COC approval, they will not get their units. But what they will get is whatever payment they have made, they will get some percentage of refund of that. So now the home buyer does not have an option. Home buyer will be bound by the provision made under the resolution plan, right? Which according to me is a again, it's not an ideal situation, but having said that, it is a good balance where the resolution applicant, because if you look at it from the resolution applicant's perspective, he makes his profit from the uh, from the unsold units. So if someone has not filed his claim, that effectively vests in the resolution applicant for him to sell it further and make money out of it, right? Because otherwise no one will come. It is normally not financially viable for anyone to come and invest, complete the construction from his own pocket, right? He has to collect the money by selling the units or from the unpaid portion from the home buyer. So only then he can complete it. No one will do it for charity. So therefore, this unsold units or units for which claims are not filed hold a lot of importance. And again, with experience, I have also seen that there are some unexplained cases where for a number of years, no one turned up, which again at times shows that perhaps the promoter would have just made certain name entries, okay, and booked units in their names, or there may be some fishy thing around it, but there was no such actual home buyer, because if anyone who has invested at some stage, he will wake up. So for example, I may have booked something in Bangalore and I may not be aware that the company has gone bust and then it is undergoing insolvency. I may not file a claim, but maybe I'll wake up after 3 years, 4 years to realize that, oh, I had booked a unit in Bangalore. What happened to that? Right. Similarly, people do such things. People from remote places also try booking something in NCR or metros in the hope, or maybe with a plan that in future it will come to some good use. But for them, it is understandable that people will wake up late, but not waking up at all is something that is difficult to understand. So we have seen cases where actually people say never turned up to claim their units, in spite of, as per the available address, etc., letters being sent to them, they never responded. So, which is actually surprising to understand as to what could be the possible reason for it. But there are such cases, which is why filing of claim, even if belated, uh, has a lot of importance. Now, according to me, sorry, I think I have broadly covered from my notes. I mean, it may seem a little abrupt, but uh, I mean, from my perspective, I think that these concepts of project-wise insolvency and reverse CIRP, etc., they need to be included in the code by way of an amendment so that there is more certainty. Because as of now, what happens is that for every whether it's the promoter or it's the IRP or the RP or the home buyers, whoever is the stakeholder, is never sure as to what exactly should they be doing and how should they actually be running the right. So they cannot say anything as a matter of right. It is as per the discretion of NCLT and LET and then Supreme Court to bring in certainty. I think it is important to have it in the statute book, which is what something that's been proposed, but again, it should be brought in soon. Let's hope that after the election in July itself, this amendment is brought in. I think that will go a long way in resolving real estate cases. They will continue to remain a problem, but I think in the long term, because of the relatively safer features of RERA, overall the future may not be as bad as it is today because we are still resolving the legacy pre-RERA cases. Even under RERA, there are some instances, but at least they are relatively better, and the future is likely to be better, according to me. But yes, the resolving uh, the legacy cases is going to be a task. Hopefully, with the resolution, JP will be a good example, and hope it gets resolved soon, even from the Supreme Court. With that, I'm open to questions if there are any.
Good evening, sir. So my question would be, since you're saying that there is lack of clarity and for the sake of stakeholders, the amendment needs to be done. So, what is the position of other jurisdictions in the world? Like, since IBC is fairly new in India, what is the position of other countries? Is there, are they implementing these things, or can we learn from them and then implement these?
See, I think real estate problem is more of a unique problem in India. There are, of course, insolvency experiences different parts of the world, and different countries have adopted different models. Like as I said, somewhere it is creditor in control, somewhere it is debtor in control, somewhere even in creditors it is a mix of operational creditors. In India, operational creditors don't have any say at all as of now, which brings in its own unique set of problems. But insofar as real estate cases are concerned, I don't know if any other country has this kind of a code and they are facing a similar situation like us. So to answer your question, I don't have a answer for your question.
Good evening, sir.
Good
Am
evening.
I audible?
Yes, yes.
Thank you, sir. So I just wanted to know that you were talking about how resolution applicants, ask the landowners. Uh, that point you were talking about. Like in CIRP, the resolution applicant, what they try to do is that they try to sideline the landowners in their respective. So just could you throw some light at how that? I mean,
Sorry, I no. What exactly is your question? What I had said was that I have seen cases where the developer is undergoing insolvency, and the land owner are sidelined because typically in the development agreement, the landowner is supposed to get some percentage of the units once they are constructed, and they have the freedom to sell them off and then make money. uh, Now, what the resolution applicant does is that they try to sideline them by saying broadly that some money that was paid to you, this is because there are cases where they have been held to be operational creditors, right? Now, operational creditor can be treated largely at the mercy of the resolution applicant, but a landowner is in a unique situation, right? So they cannot be treated like any other operational creditor. Therefore, it has its own set of problems. So, which is why I think that it's one thing to negotiate the percentage that, okay, originally suppose you're to get 50% of the unsold units or the units for you to sell it, that can be negotiated. But completely sidelining them is, I think, unfair and is subject to challenge.
okay, thank you, sir. Sir, secondly, sir, could you just throw some light on the monitoring committees? I've heard, studied that there are also monitoring committees while the resolution process goes on.
See, monitoring committee, you are right, but monitoring committee comes in after the at the stage of plan implementation. So what happens is that uh, once a plan is implemented or approved by the NCLT, there is a stage where the plan implementation of plan is not something that as soon as it is approved, it's it's considered to be implemented, because there are certain steps which need to be taken, which may involve payment of money, which may involve some approvals being taken, which may be several things which may be necessary. So during that phase, uh, and this is usually contained in the resolution plan itself, there is a monitoring committee which typically has the which has a representatives of the resolution applicant, the erstwhile resolution professional, and a representative of the lenders, who broadly oversee that the steps as envisaged in the plans are being implemented in a timely manner and properly. So that's what the role of monitoring committee is.
Thank you, sir.
Welcome.
Any other questions, anyone? Should we wrap up this class now? Thank you. Thank you, Vishwajit. It was indeed a great, insightful session. You're a great speaker, and we thoroughly enjoyed your session. And thanks for sharing the practical insight on the topic. The examples and the cases which you gave along the lecture gave us a lot of clarity and made us understand the topic well. It was indeed very engaging and informative. And thank you very much, all the participants, for joining us today. And hope you all enjoyed the session. And thank you all. Thank you, Vishwajit, again. And you all have a great weekend ahead. Thank you.
Thank you. Thank you for your kind word. And thank you everyone for joining.
Thank you.
Thank you, sir. Thank you, ma'am.
See you.
Have a good evening. Thank you. Bye.